Hello and welcome to Bulletin 140, September 2021. There are a number of interesting cases that are digested in this bulletin. The first is a case of Jacamara and the Office of State Coroner. It was a case where a mother was wanting to have the body of her son released to her, and there was a contest with the alleged de facto spouse of the young man in question. The first issue to be determined was whether there was a de facto relationship in place, which was alleged to be not the case, but in fact was found on balance of probabilities, obviously, that there was a de facto relationship in existence, or despite a tumultuous relationship between the parties. And the issue then was, well, was there anything particularly rare or compelling that should not mean that the de facto partner should be entitled to determine the burial of her partner. And on balance, the court considered that that's what should happen, and the mother's wish to have the son buried in their country, which he said was what he would have wished, was unfortunately not fulfilled. Another of these burial dispute cases, but nothing is absolutely clear-cut with them. The court has to weigh up all of the competing claims and issues, but another interesting case to have available to consider if those sort of disputes arise in your practice. The next was whether an original will, which couldn't be found, but there was a copy of this will, was in fact destroyed with the intention of revoking it. The court was satisfied that the presumption of destruction by the will maker was rebutted because there was no compelling evidence or evidence on the balance of probabilities that the will could be traced into the possession of the will maker. As we know, if it had been and it couldn't be found, then unless there was other evidence, the presumption would have applied, and therefore the person didn't die intestate. The other and final case referred to is Wiley and Wiley, and it's a case we're seeing more of where a daughter moved in with her mother. The other two children were basically, I suppose to a degree, excluded from a continuing relationship, although that's not totally perhaps the case, but to a degree it seemed to be the case, because certainly she persuaded the mother to grant her a power of attorney and also subsequently transfer the home, which was in the mother's name, into their joint names as joint tenants for natural love and affection. The court said that that transfer needed to be set aside. It was unconscionable. There was no independent advice given to the mother. And the other issue was the presumption of undue influence had not been rebutted. As we know, where there's an enduring power of attorney in existence, whether or not the transfer was signed pursuant to a power of attorney, there is a presumption of undue influence which the person who's taken the benefit of the transaction must show has been addressed, has been rebutted, and it hadn't been in this case. So that transfer was set aside, and the other question was whether the children had a family provision claim, which they had alleged, or they brought, and they were given more than the will provided for them. So just another case, I think, where the caution is that these transfers by children in these circumstances are scrutinised by the court, and it's timely to be aware of the presumption. It's timely to be aware of independent advice from a parent wishing to do that, those sorts of issues. That case is a good highlight of that need. Good reading. Thank you.